Hello, and welcome to Immigration Talk, a space where we hear from an expert on matters related to the immigration industry, law and policy, and practice. I'm Rosalie Van Staldeinen, and joining me is RCIC Tiffany Chi. Welcome, Tiffany.
Thank you so much for having me back again, Rosalie.
It's always a pleasure. Tiffany, would you walk us through the 2025 Singh versus Canada decision?
Of course. So this is a federal court judicial review that concerned the refusal of a work permit application submitted by a BC PNP nominee. And this person held a nomination certificate and a work permit support letter. The application was refused under Regulation 200 sub 3A. The court had dismissed the application for judicial review. They found that the visa officer reasonably concluded that the applicant failed to demonstrate that they could adequately perform the work sought, despite holding a valid BC provincial nominee certificate. So let's go over some background information. This applicant, Kriti Singh, is a citizen of India. She had a Bachelor of Commerce degree and a diploma in business administration. She had been working part-time with a BC company called Streamline Software Solutions Limited from December 2021. And at the same time, she was working with another company called Royal Cyber PVT Limited as a senior business manager. A year after she began working with that BC company in her part-time role, they offered her a full-time position as the Vice President of Technical Solutions. She then applied to the BCPNP in April 2023. She was nominated by the BCPNP in July 2023, and she was issued a nomination certificate and a work permit support letter. She submitted a work permit application in September 2023 so that she could work full-time in Canada. She submitted the nomination certificates, her employment contract with the BC company, her CV, and 2 reference letters from previous companies that had nothing to do with either of her positions in BC or her current position. The application was refused because the officer determined that she was unable to adequately perform the work, contrary to subsection 200 sub 3A of the regulations. The officer acknowledged the reference letters that she had submitted, but said there were no pay stubs, there were no bank statements showing salary deposits, and no other employment documents to show experience itself. So I imagine the reference letters were probably pretty sparse. The applicant argued that the officer ignored evidence, like the BCPNP support letter, but the court disagreed and found that the officer did consider all the evidence and the facts because they were all described by the officer in their notes. The onus remains on the applicant to provide the information required for an application. The court also reminded the applicant that a BC PNP nomination itself does not authorize a person to work in BC, and it does not entitle a person to a work permit. So there was no breach of procedural fairness because the required information, such as the evidence to prove that the applicant was qualified for the work that they want to perform, is part of the requirements of IRPA and the regulations. The officer is only required to disclose concerns about credibility, veracity, or the authenticity of evidence, not whether the evidence itself was complete. So this is an important case for representatives with provincial nominees because it reaffirms several facts. Number one, IRCC's work permit assessment is independent from provincial nomination decisions, and it establishes that these are separate processes. The burden is always on the applicants to produce evidence, even where there is already a provincial nomination certificate. Number two, always provide documentary evidence to support the following on a work permit application. And this includes extension, the applicant's ability to perform the work, full reference letters with detailed job description, periods of employment, salary, and education credentials, language test reports, confirmation from the employer in BC that there are no labor disputes in process, and a statement from the applicant that they have never violated any previous immigration law or policy. Evidence that the job offer is genuine, that there are reasonable needs to fill the position, a business license to show that the employer is in good standing, notice of articles or an incorporation certificate to show that this is a genuine and legitimate employer. And number three, most importantly, do not assume that you will be able to submit documents later by web form because an officer does not have to accept them even if you do send them later by web form. And an officer is not obligated to follow up with you or with the applicant to request information that was not already submitted. Rosalie?
Great. Well, thank you, Tiffany, for walking us through some of these key facts and the outcome in this important case, and for guiding us on how to consider that in our own work. Thank you.
You're welcome.
Let's talk again.